I can see that time is running, so I will try to shorten this talk. I don't have titles to share unless you mean my PhD with the Open University in the UK on the normative regulations of journalistic practice, which is actually relevant for what I'm going to talk about. The purpose of what I'm going to do in the next 8 minutes, if I see correctly.
Oh no, no, no! Don't limit yourself to 8 minutes. I think
Yeah, I
it
don't want
wouldn't
to
be
abuse
fair. It wouldn't be
people.
fair for you to limit you. Please exceed the
Okay,
time limit.
thank you. Anyway, I'll try to keep the time. I will try to demonstrate how public communication has functioned as the integral element that it is of strengthening right-based climate and energy governance within the Stellar project. This is in contrast to just using communication as a side element to the work we are doing or to the purpose of the entire project, which has been discussed at length by previous speakers. I actually thought it was a very good idea to speak last because what you heard by most of the previous speakers in a way exhausted the point I wanted to originally make, which was my first slide, that the work we are doing is positioned in the constitutional context for the European Union's structure of core values. And of course, the EU Charter for Fundamental Rights is the landmark, benchmark of the project. But there are other structures which we have engaged, and this all brings us back to the set of EU core values which are enshrined in the Treaty of the European Union. I wanted to highlight that in practical terms, this means that decisions on climate targets, energy infrastructures, transition measures, and so on, cannot be treated as purely political or technical choices. These must respect the procedural guarantees, such as access to information, public participation, and access to justice. And if the standards are not respected, they can be challenged before national court of the Europe or the European courts. The energy transition operates with within enforceable constitutional limits and not outside them. I think this is an important starting point when we are going to look how this displays into the communication environment, which we all operate in across Europe. But of course, I will be focusing mostly on the members of the Stellar project. Now, when I'm talking about, and this is my next slide, the communication challenges, I want to point to important features. First is a structural mismatch. Right-based climate and energy governance is legal, procedural, institution-focused, and complex, while the dominant communication environment which we operate in is generally commercially driven, platform-mediated, and attention-grabbing, and this creates a structural mismatch between the purposes of the legislation and the legal framework and the ability to ground it in the communication sphere. And it's a very important second element of this is the fact that commercial logic seems to shape the communication visibility of the issues we are discussing here. In a commercialized and digitalized communication ecosystem, there are some clear features which we need to consider, and we have considered when approaching this project and the work we've done in it. And these include that media revenue models are tied to traffic and engagement metrics. Platform algorithms prioritize content that generates strong emotional reactions and rapid interaction rather than understanding and analytical reflection. Detailed institutional or procedural analysis generally receives less visibility than sharp conflict-driven narratives. And an important issue which we've seen over the last 2 years very clearly internationally is that media owners, investors, the entire business ecosystem behind communication increasingly intervenes in shaping and limiting certain priorities and narratives on the field. Now, we've had to deal with all this. The last point I want to make here, and it's very essential for us as Bluelink, as an organization dealing with digital communication for over 25 years now, is that unlike traditional norm-bound watchdog journalism, which we used to be exposed to 10, 20 years ago, which has its own limitations, of course, the prevailing contemporary communication model is often structured around performance and ownership incentives, around business. It has no societal, democratic, or whatsoever normative commitment. So we cannot expect digital communication to serve any public interest purpose, democracy, and so on. Now, with all this in mind, what we have, I will just jump a bit to the further in the direction is what we have designed as an approach. Bluelink's methodology traditionally, which we plugged into this project, involves working on a structural level rather than thematic. We work with journalists and communicators not about covering a given topic, such as human rights, law, climate enforcement, or other. We try to strengthen the public conditions under which citizens can understand and exercise their procedural rights in this particular case. And this involves building a supportive participation infrastructure, which requires public communication that makes decision-making processes, participation safeguards, and remedies visible and intelligible by a great part of the public. Now, how do we do this? Our method includes training journalists in procedural literacy and offering them access to information, public participation, access to justice, and knowledge of the legal frameworks that enshrine them. Direct engagement with civic defenders of climate, environment, and human rights, but also with litigators, legal experts, and decision makers to clarify the constitutional reasoning before participation. We do workshops and other formats that combine learning and production. So not only teaching, but also getting communicators to put their hands on the actual process of doing this complex task, and cross-border publication and amplification. We try to connect the different countries. And one very recent new development, which I'm tempted to share for a second, is that we are now trying to look more strategically at voluntarily self-regulating the way we, as civil society at least, use digital communication. So we need to be able to do it in a more responsible way if we expect the rest of the communication environment to become more supportive of the purposes of our work. Now, what did we do? It's Stellar, and this is, I think, the more practical part. We tried to implement, to address the challenges I spoke about earlier. The principal approach included anchoring communication in concrete litigation cases, focused on procedural rights in energy governance, but placing it in the broader political and social context so that it could be linked to the interest and emotional, whatever, engagement of the audiences. Integrated the charter-based reasoning directly into storytelling and other communication practices that engage audiences, and addressed the digital communication pressures described earlier by adapting to formats and guidance in the implementation of the project. But the core principle is that we do not treat communication as dissemination. We treat it as an essential layer between legal enforcement and democratic participation. And I think this is a very key contribution of the project. The communication activities, I don't want to bother you much with them, but you heard already in the beginning by Csaba, most of them. What I actually wanted to highlight and spend maybe the last 1 minute, because I'm already beyond midday, is the international workshop in Budapest. Now, I want to make a clarification that we keep calling it International Journalism Workshop, but an important element and step ahead with this workshop is that we brought for the first time digital communicators. We tried to see how the traditional approaches of training journalists based on their journalistic norms and ethical and professional requirements could relate to the new situation we're in, whereby no such requirements apply on the digital communication. What was really interesting is how the workshop, and here, oh, sorry, I'm going already to slide 5 now. Yeah, thank you, Csaba. No, I'm still back, sorry. The Budapest workshop operationalized the elements I spoke about earlier. The first and interesting example is the Hungarian Constitutional Court climate ruling, which I'm sorry we couldn't hear more about today, but it really changed the mind of many of us, participants and experts, about how litigation can actually operate in absolutely unexpected environments and, first of all, achieve effect. Second of all, become a really attractive field for storytelling. We connected this to the existing legislative follow-up in Hungary, or not existing. We'll see. Csaba can tell us what's going on with this new climate bill that is supposed to be developed as a result, but also a very outstanding institution, the Future Generations Ombudsman, which is really a benchmark for Hungary for the past decades. And then we had cases from Czechia and Poland, from Bulgaria on SLAPS, from Austria, and overview of the European Court for Human Rights. So we made sure that this group of European journalists and communicators could find the relevant hooks for their further work to achieve the task. And we performed the experts, the guest speakers performed case-based legal briefings. I have to say one of them was a Constitutional Court judge of Hungary who, I mean, it's not often that as a communicator you have the ability to speak directly to such a person. A direct dialogue between participating judges, litigators, officials, and reporters, structured story development sessions, and dedicated discussion. And one last point, that particularly in the structural session, we brought in a new co-moderator. Apart from my antiquated abilities and knowledge of traditional journalistic norms as a practitioner and a scientist, we also brought a younger lifestyle blogger, book author, and a digital communicator, Reka Nagy, who actually covered the new field, the new communication field. As a result, and that's the last slide on this one, thank you, Csaba, 36 participants, 14 countries, 20 publications, and cross-border amplification. My last, and I'm finishing here, my last slide is the lessons learned and recommendations. Lessons learned. Courts and litigation are providing strong narrative anchors. Its judicial decisions offer clear institutional reference point, and they help structure complex energy debates. So that is an important thing for communicators and journalists alike. Legislative follow-up is also important wherever that exists. That makes the stories more attractive and the audience is more interested in what's going to happen. Comparative perspectives strengthen legitimacy. So comparing different member states, national dispute situations, And we already have such stories published as a result of the project, including on national television. That is really, I think, encouraging. Mixed communication cultures can collaborate effectively, meaning structured interaction between norm-bound journalism and digital communication. Production commitment ensures impact, requires concrete publication outputs. Requiring concrete publication outputs transforms training into a measurable cross-border media result. And the final lesson learned, as I mentioned, good practices may emerge in the most unexpected context. We have member states perceived as lagging in EU implementation sometimes, but exactly there we find really encouraging cases. So we should be always open for good practices. And the recommendations are different target groups. Legal practitioners should present litigation as enforcement of institutional duties and clarify procedural standards and consequences. Human rights and environmental defenders, our primary stakeholder group, should systematically document participation and access to information failures and connect cases to the EU Charter guarantees and other EU law, and we heard much better arguments for this earlier. Media and advocacy support organizations and donors need to combine training and theoretical teaching with publication pipelines and structured dialogue between journalists and legal experts. And finally, regulators and decision makers, where possible, need to treat participation and access to justice as core components of energy governance and ensure accelerated measures remain charter compliant. But this is, of course, and this is my final word, in case they and we all abide and want to abide to the EU core values and purposes that I started with and that underlies Stellar's project implementation. Thank you very much for your time and patience.